Justice isn't just about the law. It's about the people who fight for it. I'm Jennifer Long, CEO of AEquitas, where justice isn't a concept, it's a commitment. And this is Just Champions. This season, we're doing something new. We're looking at the ways sexual violence, intimate partner violence, stalking, and human trafficking crimes are portrayed in film, TV, and documentaries. Together with my guests, we'll explore how we'd approach these cases if they landed on our desks today, the strategies we'd use, what the law says now, and how we'd support victims in and out of the courtroom to set up the best possible outcomes. Because the law isn't just theory. It's the foundation of real lives, real cases, and real change. Hi, everyone. This week on Just Champions, we are taking on the BBC series I May Destroy You, which is Michaela Cole's powerful series about sexual assault, consent, and survival, and one that deals with voluntary intoxication, involuntarily intoxication as it relates to sexual assaults, male victims, just a whole gamut of issues that come up again and again when we're prosecuting sexual assault. And really importantly, the show was inspired by Cole's own experience as a sexual assault victim, and she wrote about her experience. She was raped after going to a bar and having her drink surreptitiously spiked by someone. And it really does offer a really interesting eye into the response to sexual assault, the victim blaming, the different behaviors and responses of victims, and the role of really everyone in the community, from friends to partners to the criminal justice system, in how it impacts the victims and how it helps us achieve justice. And we'll be digging into the law, maybe some toxicology and other issues around this. And doing that with me today is one of AEquitas's greatest senior attorney advisors, John Kurland, who is a longtime leader in the field of prosecuting domestic violence, sexual violence, stalking, human trafficking. He is a respected expert in the field. Before joining AEquitas about 10 years ago, he was Chief Deputy District Attorney in Berks County, Pennsylvania, where over his career he handled or supervised countless cases of sexual assault, intimate partner violence, child abuse, DV homicides. He has so much expertise, it's hard to summarize it all here. One thing I'll just point out is he is an appellate expert with whom I consult regularly when we do amicus. These are friend of the court briefs. And we have other requests for expertise that come in. I always want to sit down and talk to John about these cases. So John, I'm so glad you're here because your years training prosecutors and law enforcement and providing expertise and handling on your own alcohol-facilitated sexual assaults makes your insight into the investigative and human side of this case invaluable. So sorry for that long intro, but I'm so glad you're here.
Well, Jen, thank you for the introduction. And I always have to try to balance when I have such a flattering introduction. Should I enjoy it or feel uncomfortable? It was just the right size. Thank you so kindly. And I had a great career before joining AEquitas. It was actually 8 years ago. Maybe I've seemed longer. But working for AEquitas, I have learned so much in the last 8 years. My only regret is, wow, I wish I knew this stuff when I was prosecuting.
Let me ask you, I know this is a very long series, and I'm going to be honest. I watched it sometime around 2020, 2021 when it came out, and then I rewatched it again, but it's very long. Each episode is very long. And so I'm not sure how far into it you got, but I know that from our conversations that Annabella's assault when she's out with her friend and she's intoxicated, this is one of the, this is really how we start out. She's both voluntarily intoxicated and then although we are not given all of the facts at this point, it's very clear that she is highly intoxicated at some level of when she's out in this bar. And I'd like to actually have you start by talking a little bit about these cases. As a prosecutor, when you're dealing with a case where a victim has been intoxicated, can you give us a brief summary of the law and how it handles victims who are voluntarily intoxicated and those who might be involuntarily intoxicated? Not as it should. We're going to get to that in a moment, but as it is.
Sure. Well, generally speaking, a lot of laws that prohibit sexual contact, and by sexual contact, I'm including everything from sexual penetration to other forms of sexual contact, but I'm just going to use the word sexual contact in a global way. Generally speaking, there's some nuance about this in most jurisdictions, but if that happens without a person's consent, it's a crime. So with alcohol-facilitated sexual assault, or AFSA, what occurs there is if someone is too intoxicated to have capacity, which is capacity, I think, is a pretty straightforward term, but it's just a legal way of saying the ability to give consent, then that kind of sexual contact would be or can be criminalized. So even if someone becomes voluntarily intoxicated, that's in most jurisdictions known to the perpetrator or known to the offender or should be known by the offender, then it's a crime if some kind of sexual contact occurs if they didn't have the capacity or the ability to give consent. Alcohol-facilitated sexual assault, it's not just focusing on someone who's had some drinks, maybe feels a little buzz or tipsy, and makes a decision they regret later. What alcohol-facilitated sexual assault is contemplating in someone who's intoxicated to the level that they really don't have the capacity to make decisions, just as they might not have the capacity to drive a car, just like they might not have the capacity to enter into a legal contract, sign a mortgage, get a tattoo, or things of that nature. The other form, and they're sort of separated in the law, but when you think about it, they're in real practice and in actuality, they're always overlapping, is the involuntary intoxication, is when someone secretly administers either a drug to a victim or something that causes them to be intoxicated without their knowledge. Involuntary intoxication, a lot of the statutes call it surreptitious administration, which is I suppose the law trying to elegantly say sneakily or secretly giving someone an intoxicant, which is essentially what it means.
Right? Spiking a drink. Mm-hmm.
Spiking a drink is the other kind where the victim didn't voluntarily become intoxicated, but they were involuntarily intoxicated because they didn't know they would be administered the substance that caused the intoxication. But and this is what I thought the show presented so well. It's not often those involuntary intoxication cases are going to be happening in a context or environment where it's just involuntary intoxication. Usually it's going to be happening in an environment where the victim is already, I mean, I guess you would say partying or drinking or voluntarily intoxicating. Inhibitions are a little bit down. I mean, usually involuntary intoxicants, I don't want to say never because I try to stay away from categoricals. But usually someone isn't, our friend Jen Summers, who's helped us develop a lot of materials on this, always points out, usually someone's like Diet Coke isn't spiked while they're in the line at CVS. Usually it's going to happen somewhere where you're out, you're about, you're having a good time, you're drinking already. So the involuntary is usually always overlapping with the voluntary, which is what I think the series really depicted pretty well. And when I say voluntary, and I use that term to suggest that the victim wasn't coerced into having an intoxicant or to drinking or to doing drugs. But again, in real world scenario, I mean, sometimes the victim was, anxious and happy and actively sought out the intoxicant. Doesn't make their sexual assault or sexual violence any less of a crime. But more often that voluntary intoxication is almost sort of pressured and cultivated and almost groomed by the perpetrator. So it is technically voluntary intoxication in those cases, but we want to recognize the sort of design and plans of the offender and in exploiting that and developing that situation too.
No, and I mean, again, at the risk of weaving all around, which I do in so many of these episodes, I just do want to remind people that Jennifer Summers was a guest for us on
That's
season
right.
1. So you should definitely go back and listen because she gets into a lot more depth than we may be able to here. But already, John, so there were so many points you made. I guess the first one I want to start with is where the law is and how brilliantly you just really put it out there. Look, it doesn't matter how someone became intoxicated from a practical matter, because that when that intoxication has interfered with their ability to consent or their ability to be aware of what's happening to them. And so from a, victimization perspective, grounding us in that was really important. And from then the legal perspective of the blueprint we're following, we're going through and either looking at laws that are specifically call out that they protect victims who are voluntarily intoxicated. Some will be specifically to be applied when a victim's drink was spiked. And then sometimes we have to look at other laws that don't precisely discuss intoxication. They may be discussing the impacts of the intoxication to someone physically or mentally. And then we'll be implementing those laws. But I mean, I think the point you made, which was really well taken, is that the law's there. And as the prosecutor, we're navigating which one to take. And the second thing I think I loved, there were so many things that I loved, Juja, but I also loved the importance of saying, look, this is when individuals are victimized, typically they're in a situation where they are feeling comfortable, they're feeling safe. Again, you're in a public place. In this case, Annabella, the character in I May Destroy You, she's in a public place. She's celebrating. She's with a good friend, an old friend, if you will, and then a bunch of new friends. A friend of her friend that they've met and they're celebrating, and then some new people that are together. And again, you let your guard down. You come in and you are drinking. And at this point, she is drinking and being observed by her rapist, which we find out a little bit later in the series who that is. But at the time, again, I think our colleagues, I've actually heard you say this so many times, people have a lot of things that they should expect should happen to them when they're drinking too much. They may expect, okay, I'm going to be sick the next day. They may expect maybe I'm going to be a little bit loud. I might have a headache. But what they're not expecting, what none of us are expected to expect, is that you're going to be raped because of a decision to drink or voluntarily use drugs. That's not a natural, reasonable outcome of what people are thinking about when they are engaging in totally legal. And in some cases, okay, the drug use is illegal, but the outcome of that is not that you're raped. Maybe a reasonable outcome should be, wow, if the police come in, maybe I'm going to be arrested for possessing or using these drugs, but I'm not going to be raped. So how your experience as a prosecutor, when you're approaching these cases and you're meeting with these victims, what's your goal when you're meeting with them? I'm sure there are many goals there in terms of both getting the information from them, but also helping them cope with the fact of their rape.
Sure. I think I need to back up a little bit first, because so much of the culture when an alcohol-facilitated sexual assault happens, especially in those voluntary intoxication. The involuntary intoxications always have proof challenges and evidentiary challenges. The voluntary intoxication challenges, I think there's a few of them, but I think one of the biggest barriers is the culture, sort of, as you were articulating just there, the culture always puts the blame on the victim for putting them in that position, like the jogger who runs through the high crime park late at night or something like that. It's the same sort of analysis rather than that focus on the offender. And so with that sort of cultural perspectives, victims have that too. And so when it happens to them, and a lot of the victims I've talked to and have worked with, they're putting the blame on themselves for what happened, for drinking too much, for essentially, in their mind, creating that vulnerability that let them be exploited, be perpetrated against. So I think the first thing to do is try to have conversations with what you're trying to do on the law. And I don't think you should do this in an ivory tower or esoteric way, which I might be doing too much during this podcast. But you talk to the victim and let them know, and I think this is good for any kind of conversations you're having with the victim, is you pull back the curtain as much as you can. That you're as a prosecutor, as an investigator, this isn't McDonald's where we're trying to keep Burger King from finding out our secret sauce. But we let victims know as much about why we're trying to ask questions as possible to inform them. And so during that conversations with the victim, and this is an oversimplification, find out like, hey, listen, I want to find out how much you had to consume that night, how intoxicated you were, not because I'm trying to embarrass you, but because if I can show that you were intoxicated, then that sexual contact was a crime under the law and just under, I mean, frankly, I think sometimes good sense. If you're too intoxicated to give consent, that's a crime. And so when I'm asking you these questions about whether you did any drugs, what if any drugs you consumed, how much you drank, and questions like that, as well as other questions, the reason I'm asking that is to find out how intoxicated you were, or how well I can prove your level of intoxication, so I can hold the person accountable for who did this to you. And that's why I'm trying to find out answers to these questions, not to embarrass you or shame you. And I think sometimes I've had some conversations with victims when I frame it that way, where, hey, listen, I want to hear about your vulnerabilities so I can prove my case. They're like, oh my God, then just that's why they want to hear. They want to learn about my vulnerabilities, not to make me look like an idiot, but because they want to prove the crime that happened to me. Same thing, and I mean, I'd analogize it too. If I'm talking to someone whose house was burglarized, if I'm asking questions like, hey, was your house locked? Was your alarm system on? And it wasn't, I'm not trying to make them feel stupid for not doing that, although I'm sure they might feel that way or take it that way. I'm trying to find out how the person could have gotten access to their place. And that analogizes pretty closely with, I mean, the kinds of questions we're trying to find out with really any victimization. You're trying to find out what was the real or perceived vulnerability that an offender identified and then exploited. And sometimes that vulnerability is going to be trust. Sometimes that vulnerability is going to be intoxication. A lot of times it's a combination of vulnerabilities that an offender is thinking about, developing, and calculating how to exploit. And we're finding out about those vulnerabilities not to embarrass the victim, but to try and get justice. But I think explaining that to the victim and sort of revealing the whys about our questions as much as possible is the best way to go. The presumption should be telling the victim everything we can. And I think if we're not doing that for something, we better have a very thoughtful reason for not doing that.
No, and I was just thinking, I mean, in listening to you, I go back again to season 1 and thinking about Jennifer Summers, and of course, someone you and I have heard speak and who we've collaborated with on many occasions, that, you know, there are a lot of things that impact the level of intoxication, and that, you know, oftentimes individuals can underestimate what they're drinking. And so for certain, we want to get information. And what a victim's reported drinks might be, it might match the level of intoxication they had. Or in a situation like this, you can also have a victim reporting the drinks that they've drank, the drugs that they've used. And again, sometimes when we're asking if they've used them before, not that you can't have a situation that's an outlier, but in this particular case, if all of a sudden you are now experiencing something that you haven't experienced before, or that's not commensurate with the amount of alcohol or the type of drugs you're reported using, then it indicates to us that maybe something else happened, and it helps us identify, okay, what should we be looking for in tox screens? What should we be looking for if we go back to the bar? I mean, probably technology has changed so much, even when the series was filmed, let alone when Michaela Cole actually was raped. But the number of surveillance cameras that can be in a bar or number of ways that we can go back and try to identify information becomes very important. So also getting this type of information so we can understand, and I think you laid it out beautifully, that always remembering to remind the victim that we're not asking questions that are seeking to lay blame. We're asking questions, and this is the reason why, so that we can start to learn information. I know I'm jumping around a little bit, but just thinking about the impacts of alcohol, because there is the blame piece and things that we can overcome that way. Then there are some real barriers that can arise. And in this particular case, this victim suffers from what we'll call partial blackout and does lose parts of the night, and then does recall different parts of the night as the season goes on. And in that case, too, that's going to create some barriers because we might be missing pieces of evidence. Can I ask you very quickly to just describe to people what a partial blackout is and some of the strategies you use to overcome those gaps in information?
So usually the issue, or often the issue in the case, is going to be a pass out versus blackout type theory. When there's a pass out and you can prove a pass out, the thing that's easier about that is if you have evidence that a victim was passed out, it's pretty easy to prove that it's non-consensual or that any sexual contact that occurred was non-consensual. The bigger challenge is usually sometimes trying to prove the nature of sexual contact, because the victim's consciousness wasn't there during a pass out. But a pass out is essentially equivalent to what happens when you get put out for surgery. A blackout is distinctive as just in definitional terms, and that a pass out, while you don't have any conscious memory, during a blackout, you are conscious, but the part of your brain that's responsible for sort of organizing or keeping memories, your hippocampus, is basically compromised. So while you're conscious during it, your mind doesn't have the memory to retrieve it during a blackout. The memory's essentially gone. And what they've done, and what I've learned from people like Jen Summers and from toxicologists, is a blackout isn't just predicted by someone's blood alcohol level, their BAC level. Rather, what really determines a blackout is going to be a rapid rise in BAC rather than a more gradual rise in BAC. So if there's evidence of someone having maybe a lot of intake of alcohol in a short amount of time, like say a succession of shots or a bunch of shots for a birthday party, there's more evidence or corroborative evidence that maybe what happened to them was a blackout. If there isn't evidence of that sort of rapid rise in BAC, the idea of a blackout is going to be less supported. If a pass out is usually going to be consistent with, again, not having memories, but also when you come out of a blackout, it's almost going to be like those groggy effects you have after surgery, not just a hangover, but where you're just out of it. And rather than just a strict hangover or something like that. So if the victim is disclosing to you, like, hey, after they came to the next day or when they came to, they were groggy, they were out of it, and not just a sort of crappy hangover type feeling, then that's going to be more consistent with a pass out than a blackout. Now,
can I just interrupt you for a second? I'm just curious. So when you have cases with this gap, how do you fill in the gaps? Like, where are you going to go to try to look for evidence that might help you piece it together? And in this case, spoiler, hers is a partial blackout. So there are pieces of the night that she remembers before, during, and after. So there's some leads that she can give us. But understanding that this assault takes place either in the bar that she starts in or at a secondary location, knowing the witness, like where she was and maybe how she traveled. She has a memory of an ATM withdrawal. What are the type of things that you do as a prosecutor, what you're looking for as evidence that can fill in the gaps?
Well, when there's a partial blackout, that's important, because if there are memories, alcohol can certainly impair memory, but it doesn't create memories or nothing specifically about the nature. In other words, alcohol is a central nervous system depressant, a CNS. It's not an hallucinogen. So while you certainly might have the ability to sort of retrieve memories because of intoxication or with a partial blackout, the memories you do have are not inherently unreliable due to the alcohol. So if someone has fragments of memories, like from a partial blackout, those can be, all things being equal, reliable starting points. And so that would be one area I would go from. I would try to find out and I get those sort of, looking at the victim's disclosure is not the be all and end all, but the foundation for an investigation. And so whatever sort of elements or disclosures I can get from the memories from a partial blackout, I would want to try to find ways to corroborate it by either talking to other witnesses at the scene, witnesses before or after, looking for things like video surveillance, the people who worked at the bar, maybe if they were using ride shares or cab. I don't know how many people do use cabs every now and then, but if there is a cab driver, driving records, financial records that show point of sales and things of that nature that can help me sort of build up a timeline and piece together a trail. Another alternative, and again, I want to say this not as something categorical or anything like that, because it does have to be cautious, but this is sort of one tactic, but it has to be considered, is using intercepted recordings or consensual recordings. And I don't want to say that is a be-all, end-all solution. Sometimes the victim might not be in a space to do that. Or want to do that, and that's not something we want to impose or force. And not always. And you might have a savvy enough offender that when the victim talks to them, they are smart enough or savvy enough not to give any sort of thing that's incriminating. But it can be a tool. But like any tool, just if you have a variety of tools in your tool belt, it doesn't mean you use them. You don't use every tool for every job, but you recognize the tool as an option in the appropriate circumstance.
No, 100%. And I think there's so much to talk about here. And but before I move on from Annabella, one thing that I thought this series did very well is highlighting some victim behaviors, although this is a victim who does report right away with a friend, and there's scenes talking to special victims unit, there's scenes talking to the police, and there's indicia of how long the investigation takes, which ultimately is closed without identifying a suspect. But the victim herself, we see some things that as prosecutors or from the outside world, we may not be able to see, impacts to the victim's work and maybe impacts to relationships. But the victim is also socializing. They're continuing to go out. They are not in the fetal position at home. And towards the end of the series, they're actually going back to the scene of the crime and in an attempt to identify, because the perpetrator isn't identified, in an attempt to identify the perpetrator and perhaps confront them. And I feel like one of your areas of expertise are these victim behaviors. And we always say understanding them. It's not because we are blaming the victims or feeling like they need to be explained, although we know that sometimes our community does need an explanation, whether that's fair or not. It's what it is. But it also helps us. It's very offender focused because it helps us put to bed any of those questions. But I'm wondering if it's common in your experience that a victim would have this different range of behaviors, and just briefly how you handle that in a case.
Sure. I generally, what I've learned through experience, and candidly, this was a learning curve that I had to grow to from the beginning of my career, late 90s, early 2000s. But really where I land now with the benefit of experience and training is you cannot judge whether an assault occurred or didn't occur from victim behavior. Whatever a victim behavior does in response to violence, whether it's sexual violence, intimate partner violence, is right. That can include things like curling up in a fetal position. That can include things like engaging in risk-taking behavior. That can include things like going back to the scene or having contact with the offender. Basically, using victim behavior to try to decide whether an assault did or didn't occur is unproductive, because it doesn't do anything to show it. That said, I will say that I think often the stereotype of victimization that's sort of relied on is that of the princess in the tower. The princess in the tower, where the ogre comes, smashes in, and takes him away, and what have you. And well, certainly that kind of archetype can happen. Offenders are too varied and victims are too varied for that to be any kind of rule to follow in trying to understand victimization. So therefore, when I'm looking at victim behavior, whether it's someone who's really withdrawn, whether it's someone who's really clingy, whether it's someone who tries to normalize their life after an assault, none of that does anything to tell me about whether the assault occurred. Problem is you're a prosecutor and a litigator, and you got to prove your case. Many people are sort of not having that understanding about victim behaviors. I like to think because thankfully most people in the world don't have a lot of experience with sexual violence and intimate partner violence, so they don't know what they don't know, which can't be helped. And so they don't have even the perspective of known unknowns. So really what you want to do is you really need a kind of evidence that can educate them about victim behaviors, not to show that certain behaviors prove a rape or sexual assault occurred, but to help a jury understand that certain behaviors aren't proof that a sexual assault didn't occur. And I think probably a really great tool to help explain that is going to be expert testimony. And in AFSA cases, there might be lots of different kinds of expert testimony you want. Maybe you're going to need a forensic toxicologist. If there's DNA evidence, maybe you're going to have that. Maybe if you had a really good investigation, there's going to be crime scene processing and things of that. But when I'm talking about victim behavior experts, I'm talking about an expert who the minimum basis of their expertise is they have a wide body of experience with victims and working with victims so that they have knowledge that the average person in the jury doesn't about the different kinds of responses that victims have to sexual violence, intimate partner violence, to human trafficking, what have you, so that the jury can then be educated based on this person's experience that this behavior, ultimately what you want the jury to understand is this behavior or the presence or absence of certain behavior does nothing to help us understand whether a crime did or didn't occur. To figure that out, the jury's going to actually have to look at all the evidence and weigh the evidence. We can't look at behavior as an easy way to figure out what happened or didn't happen in a case, and that helps do it.
Another area where this series did very well is dealing with male victims and dealing with consent in a different way. And this is a male victim who meets his rapist via an app, via Tinder, I think, or some similar app, I should say. And I raise that because I'm going to want to talk about it because it's an app that the one that he uses is specifically for hookups. And it's specifically, sometimes you don't even know the individual's name. And the rape that happens to this individual, he is completely sober. The victim in this case, the rape happens after a consensual encounter with the rapist, happens immediately after. It is very clear that our victim, Kwame, in this case, doesn't consent. And I thought the series did a really beautiful job of looking at a rape in this circumstance through the eyes of this victim, dealing with a male victim, dealing with that male victim's reporting to the police. And it's a totally different experience. He, instead of engaging with clearly special victims detectives, he's engaging with an officer that looks or by the response doesn't seem to have a lot of training or a lot of expertise with sexual violence. And also, and this, I think, any people who are assigned to these cases could be guilty of some of the blaming language that came out in this. But I wanted you to talk a little bit about consent in this case, and specifically a person's right to revoke consent, how we proceed in a case like that, and, what defenses you imagine might come up in a case with the facts as I laid them out.
Sure. The revocation of consent, that again also needs a lot of education. I don't think that's always as often a legal challenge as it is as much a cultural challenge. And so one of the things I would be trying to get to do with a jury is if the evidence proves that revocation of consent, I would want the jury to understand from the beginning that whatever your personal beliefs are, that they could apply that point of law. That if they find the evidence was removed, that proves that consent was revoked at a certain point during the physical act, then a crime was occurring. And I would try to get my panel educated about that, because the worry is that the personal feelings of a jury or the tendency of a jury might be at a certain point during a sexual encounter, one person's urges become uncontrollable and they can't be contained, and therefore that removes criminality. I don't think that's correct as a matter of fact. I mean, I think the analogy, our friend Dave Thomas, who we sometimes teach with, always points out when offenders have used that excuse with him. Okay, let me ask you, if the victim's parent or a uniformed police officer walked in on you, would you be able to stop? And of course they would. To show that, I mean, you do have control even when you're in the middle of the act, and that it isn't uncontrollable or anything of that. But as a legal matter, that doesn't apply. So I'd want to be sure that that could be recognized and that could be applied. So I think that's going to be the primary challenge, is getting people to sort of put down their personal feelings, and maybe personal feelings sort of given that have been cultivated in a cultural context in deference to the law. Now, there's going to be proof challenges a lot in those cases, because the victim says consent was withdrawn. The offender might frame it as, oh, that didn't happen. I didn't know consent was withdrawn, or I didn't understand that was true. And so really, I think then we really want to do a lot of the strategies we're otherwise doing in sexual violence cases, which is looking for ways to corroborate the credibility of the victim. Like, why would the victim come forward and disclose this if this isn't how that happened? The interest in the offender as framing it otherwise, highlighting the sort of barriers and challenges to a victim's life that happen when they disclose and come forward in an effort to get justice, and how usually their life gets harder, not easier. And I think also making the argument, hey, and I've done this in cases too, where there was revoked consent and the credibility of my victim was attacked. Like, look, if this was something manufactured by the victim, they could just say they never consented. They wouldn't have to say they revoked consent. So it doesn't, from a sort of reasonableness perspective, it wouldn't, I don't think it's reasonable to expect a victim to say, hey, look, I consented at first, but then revoked. If a victim is doing that, I think that's sort of you're not trying to put a round peg into square holes when you sort of appreciate that disclosure for the nature it is.
You really explained that so well, and I was so excited by the different scenarios. I sort of jumped to revocation of consent and jumped over what also was, I think, more precise in this series, which was a case where, and it happened in the same interaction, but a case where there was fully consensual sex, multiple times perhaps, even sex that involved, outside observers. And then after that encounter was over, our victim dressed, our victim was set to leave. The perpetrator prevented him from leaving, forcibly put him down on the bed, and forcibly raped him. And so you have that. And I think this is also, gives you another opportunity to talk about consent and the definitions of it, and why it's so important that consent is understood to be to the specific act. We talk about this a lot. Consent to one thing does not mean consent to all things. And I'm wondering how you also deal with that situation with your juries.
Well, I would approach that, and again, a lot of it's going to be contingent on what evidence I have in that specific case. But generally, I would just try to frame that from an offender-focused perspective. And the idea is like, look, if you have someone who is perpetrating, what a great opportunity to perpetrate. It's easier for an offender to perpetrate a victim who they already have access to, which they do have access to in some kind of relationship, or if there is prior consensual activity. It's easier from an offender's perspective to perpetrate against a victim who on some level they've cultivated that trust. And essentially what I'd be trying to sort of reveal or sort of to highlight this argument is sort of evidence that reveals that predatory kind of conduct. But I think some of the same arguments I was making with that revocation of consent would also apply with that victim. Is, again, if you're attacking the credibility of the victim, why would they first, if they're first disclosing a consensual relationship, why would they then subsequently disclose the non-consensual interaction? Now, of course, a lot of victims, and I have to recognize this too, and this might be something we have to explain, a lot of victims where that dynamic exists, like an initially consensual relationship and then a later non-consensual relationship, some victims may be sort of scared to disclose that because they're like, oh, wow, if I talk about the prior consensual activity, are people not going to believe me about the non-consensual activity? Am I going to be judged for that? Are they going to think I'm stupid or I brought this on myself? So I do want to recognize and appreciate that when victims are disclosing, that they may first only feel comfortable talking about the non-consensual component and not necessarily comfortable talking about the previous consensual elements. I think what we want to be doing is, again, that victim behavior expert maybe can help juries understand patterns or why victims sometimes do that. Sometimes maybe even our victims can explain that later on, why they were scared to do that or uncomfortable doing that because they were worried about not being believed or not being trusted. And then again, we can show the rest of the effort. But I think we also want to be recognizing too the nature of disclosure. And this is something we want to be educating our juries about. The nature of disclosure throughout a case, it's not an event, it's a process. And I know so often we're sort of, and maybe for media, and I don't want to call out specific media shows or things like that, but just the nature when you have to fit a drama into 30 or 60 minutes, the disclosure necessarily has to be an event because we got to fit our story and entire story up together. And that's one thing I think the show did well is that disclosure is a process. It's not a one and done event, and then we wrap it up with sobbing as the jury announces a guilty verdict. But the disclosure of something that happens is a process. Some of that is a process because of internally what the victim has to do and deal with something that's awful because no one's planning to be a victimization. It's not something that anyone was ever planning to be a victim. And so coming to terms with that can be hard too. Sometimes that disclosure is a process too, especially with criminal justice folks like in prosecution and law enforcement, is because we haven't earned the victim's trust yet. And we have to get that victim's trust before they feel comfortable telling us or safe. I should say comfortable. I should say feel safe telling us.
And I think you did such a great job putting together, what we see on the screen and some of the positives and the negatives on the screen, and then talking about real life cases and the real life issues that we're dealing with. And I'm wondering if I didn't want to ask you. I know we've gotten better. We're not where we want to be. We've certainly gotten better at prosecuting sexual assault cases. What can we be doing to really be achieving justice for victims and to make sure that they feel respected and have dignity through the process?
Well, I'm not talking politics, but I think the great thing of living in a sort of federalist system with all these different jurisdictions is that there is a big laboratory of jurisdictions for us to learn how to do the right thing. And that's, I think, one point to remember is that there isn't any one right way to do these cases. There's certainly practices that might concern me or alarm me, but looking at the glass half full, there's lots of good ways to do this. And there's lots of different ways we can learn to develop practice and figure out what works. I think in an idealized sort of practice, what I would want to be doing, and as a prosecutor really worried about public safety and victim safety and appreciating the dangerousness of these offenders, as well as wanting to get justice for these victims, in as much as possible in terms of prioritization of prosecutorial resources and investigative resources, I would ideally wanting sexual violence cases, especially ones like AFSA or ways that are sort of accomplished through more nuanced methods of perpetration or sophisticated methods of perpetration. I'd want the sort of resources to the investigation prosecution of those cases to be equivalent to what we would be doing for things like homicide, for things like drug trafficking organizations. And by making that analogy or comparison, I sort of idealize drug trafficking organization investigations or homicide investigations because generally speaking, there's a prioritization of that and a kitchen sink approach. Like, let's see what we can do. Let's talk to everyone we can. Let's follow as many evidentiary leads or threads as possible. Let's figure out ways to make it happen and to make it work. And I think that same sort of approach, and that approach does happen in different jurisdictions. I'm not trying to say it's an exception, but that sort of prioritization to sexual violence and candidly intimate partner violence, stalking, and human trafficking too, is probably a great mindset or a great starting point.
Well, John, I really thank you for sharing your expertise and for, watching I May Destroy You. I know it's a difficult watch. I actually had this conversation with Rick Hurdle, who I spoke with a couple of episodes again. Even though we do these cases, we work with prosecutors and law enforcement and other professionals and giving expert consultation. It's still, they're still difficult to watch. And again, with so many dynamics and so many issues going on, I really appreciate that you helped us navigate these challenges with compassion and precision. So thank you for that. But before I let you go, I think you know what's next because we always close with 3 quick questions. They're sort of rapid fire-ish. So I wondered if it's okay if we go through them with you. Here's my first question. If a movie about your work as a prosecutor were made into a TV series or movie, what detail would you insist that they got right?
I would insist they get right the tens and hundreds of hours that I am staring at documents on my computer and making outlines of discovery. The things that don't really lend to good TV watching, but I think would give a better perspective on a lot of the background to prosecution. Like doing trials fun, giving a closing argument, having everyone watch you, being there when the verdict comes in and that sort of pregnant moment when you don't know what's going to happen. That's all great. But I think just the sort of prep work that has to go into that, if that could be sort of conveyed in something more than a montage. So maybe just 4 hours of a single camera at my desk typing on a computer.
The real work
Yeah.
that gets to the successful outcomes. No,
Yeah.
I hear you. Okay, here's the second one. What's one thing that Hollywood never shows about sexual violence or domestic violence, trafficking, stalking, that you wish people understood?
How varied and wide-ranging the reactions and behaviors of victims can be.
Yeah, and this one did it actually very well. Although, again, every victim is an individual, so it doesn't show everything, but it definitely showed a wide range of reactions. Last one. Why does this work matter to you personally?
Oh gosh, so many reasons. I never. I didn't really have a specific plan to be a prosecutor. I mean, I graduated from college with a history degree. Law school seemed like a pretty good sequence from that, but I was always tangentially interested in criminal justice. But and again, I don't have a big catalog of other professions to compare because this has been my life's work. But this has been, I can't think of anything more rewarding than what I've done as a prosecution or forwarding the mission of prosecution as I've done with AEquitas. Getting to help and work with people who need help, who are vulnerable, working to hold people accountable who are dangerous to public safety, to victim safety. And also just the sort of very interesting, the intellectual and evidentiary issues that come up in the litigation of this and trying to prove these cases. And ultimately, I think it's a phrase in prosecution that has sort of developed in my career is what the job of a prosecutor is. And I'm so appreciate I grew up in this era where being a prosecutor means you get to do the right thing for the right reasons. And by this, I don't mean to minimize the work that other attorneys are doing. Defense attorneys do critical work, and the adversarial process, what the defense attorneys do, is what makes our criminal justice system so reliable. Because as defense work gets better, prosecution has to get better. but it's just it's the most rewarding thing that I ever could have imagined.
Well, John, this was such a great discussion. Thank you again so much. I really appreciate you being here and bringing your experience to Just Champions and to AEquitas, by the way.
Thank you so much, Jennifer. I appreciate it so much. And thank you for the recommendation on the show.
Thank you so much. This podcast discusses the violent crimes of sexual violence, domestic violence, stalking, and human trafficking. If you need support, please check the show notes for links to hotlines and agencies that can help. For more information about AEquitas, please go to equitasresource.org. That's AEquitas resource.org, or follow us at Equitas_resource on Instagram. This series is executive produced by Jennifer Long, AEquitas, and Robin Hopkins. This series is sound designed and edited by Dan Kroll. This season of Just Champions is funded by a generous grant from the U.S. Department of Justice Office on Violence Against Women, supporting efforts to improve justice in cases of sexual violence, intimate partner violence, stalking, and human trafficking. The opinions, findings, conclusions, and recommendations expressed in this podcast do not necessarily reflect the views of the Department of Justice Office on Violence Against Women.